All right, the next case is from the Workers' Compensation Board. It's number 128592, Thomas Wood versus SB Manufacturing, Inc. Who do we have here for the appellant in this case?
Your Honor, Tim Emerson on behalf of the appellant, respondent, SB Manufacturing.
And for the appellee?
Robert Lee on behalf of the claimant appellee, Your Honor.
Let me begin by indicating something. This is a workers' compensation case out of Wichita. Both parties are from Wichita. Both attorneys are from Wichita. I think there was some sort of a scheduling snafu as to why this case is being argued in Johnson County. And I guess I just want to note that, and I'm sorry if this caused you any trouble to come up here to argue this case.
Not at all. Not at all. Our Overland Park office is up here. It gave me the opportunity to go and visit the people who I never see on a regular daily basis. And some good food, barbecue.
Well, in any event, Mr. Emerson, when you're ready to proceed.
Thank you.
Do you wish to reserve any time for rebuttal?
I do 5 minutes, Your Honor.
That is granted.
May it please the court. I'm Tim Emerson. I've practiced workers' compensation law in the state of Kansas for 27 years. I've practiced on the side of injured workers. I've practiced on the side of respondent employers, from small mom and pop operations all the way up to companies like Walmart and Boeing. I also practice for the Kansas Workers' Compensation Fund, which, if you're familiar with that entity, steps in when there is a situation where an uninsured respondent needs some help paying the interim bills for a claimant who needs immediate assistance with medical and wage replacement. So in those cases, I am often, if you want to put it in certain terms, on the side of the claimant or on the side of the respondent, depending on the facts of the case. And in law school, we heard that theory that we would rather let 10 guilty go free as opposed to convicting that one innocent. That never actually sat right with me. The person I thought of when hearing that was Tom Robinson from that wonderful To Kill a Mockingbird. The workers' compensation application of that would be that we would rather deem 10 rather bogus claims admissible or compensable than deny the one legitimate claim for a claimant who's navigating the workers' compensation system with a legitimate injury. When we talk about letting 10 guilty go free or letting 10 bogus claims pass through, doesn't mean we should ignore the applicable burden of proof. And here in this case, with all respect to the bodies who I've appealed on behalf of my client in this case, it looks like they ignored some things that I believe should have been paid more attention to.
Not to put too fine a point on it, but it seems to me that the bulk of your brief to us is a request for us to reweigh the evidence, because there are things that bear on the claimant's credibility. And I mean, I think the board acknowledged that, certainly in passing, but how is what you're asking us to do not simply reweighing the evidence?
I think there's a fine line between reweighing the evidence and actually considering the evidence. And the reason I say that is this: of course, the standard is under 77-621C. And I have a much more uphill battle before your honors than I did at the board level. The board is allowed to engage in de novo review. Your honors are not. But it does state when we're here in front of the Court of Appeals on a workers' compensation matter, if the action of the agency in this situation, the appeals board, was based on determination of particular facts. You look at the evidence that is substantial when viewed in light of the entire evidentiary record. And I think the arguments that I've made in the brief, and I stand by my brief, many of them, as I was citing to the record, citing to the very factually driven situation we're in here, I did worry about whether this would be seen as a reweighing of evidence as opposed to determining, here's the entire evidentiary record, why was this part not focused on and this part was focused on? I believe the evidence that was given by the two expert medical witnesses in this case that the ALJ relied upon and that the board relied upon actually had flawed information when they made their determinations, their medical conclusions that also led to the vocational conclusions. Because in workers' compensation settings, a vocational expert can come in and give opinions on wage loss and task loss, but much of it is relied upon in light of what the doctors have said. So I acknowledge the question.
Effectively asking us to declare the claimant literally incredible, as the dictionary defines that, is he is not believable as a matter of law. Do we have to make that finding to rule for you?
And I'll back up for just a second. I think you can absolutely come to that conclusion because we have.
What do we have to, though, to find for you?
I think you do. And I don't think that that's necessarily looking at the truth or veracity of the claimant. I think it is looking at evidence that possesses something of substance and relevant consequences that induce the conclusion that the award is proper. And that comes directly from the standard of review in workers' compensation cases.
That seems to me slightly aside from, I mean, I'm asking you, if we have to issue an opinion that says the claimant, as a matter of law, had no credibility whatsoever to reverse. Is that your position?
I don't think you have to do that in order to reverse, but I think based on the facts that have been presented, you could certainly reach that conclusion, Judge.
I mean, that's a fairly extraordinary finding.
When looking at the standard of review, and I would invite being corrected if I'm wrong, but if I break it down into the simplest terms, it ends up with this question: would a reasonable person accept the evidence about the March 6th non-work accident? Because there were three witnesses who gave information about an accident that happened completely outside the workplace. And that accident ended up having an impact on the claim of an accident that actually occurred at work. It was only after hiring counsel and only after it came time to sit for a deposition that his story completely changed. And there is nothing that supports that story other than the claimant's testimony himself. Looking back at the original information that was gathered in the case, we actually have three people who are able, including the claimant himself, who are able to describe an accident that happened at home, falling into a bathtub, a rather significant event. They want us to conclude later on that, well, that wasn't as significant as the second event where he lifted 17 pounds. We have the testimony of claimant himself saying that he couldn't walk, he had to lay down, he had difficulty even getting up to go to an appointment after the bathtub incident at his house. Dr. Zotterer comes in and says, this is what I was told. He had an accident at his home. It was significant enough for us to give him a Toradol shot.
I'm sorry, I didn't mean to interrupt. I've read the brief. I mean, I understand the argument you're making and the evidence you marshal about credibility or lack of credibility of the claimant. Is it your position that the claimant's representation that he was actually injured in August is false, and that we should conclude that there was no injury at all?
We made that argument later simply based on the stories that he told during his testimony. He gave testimony multiple times in this
Again,
case.
do we have to make that finding or that determination to reverse?
I don't think you have to make that determination to reverse, but you could certainly come to that conclusion. We later wanted to change our stipulations to indicate, because based on everything that we have heard to that point, we have the claimant's own testimony, we have Dr. Zotterer's testimony, we have the text messages that he sent that week in March where this accident in a bathtub at home occurred, the same week in March that he later testified at his first deposition that, well, I was lifting a tire off a street sweeper at my employer's business during a period of time that he wasn't even working. He wasn't even there to have done this.
Well, that's a little bit squishy.
I think the evidence was pretty clear. He was gone from March 7th to March 11th.
Right, but he was sort of hedging on what the precise date was that he had reported it, right?
He gave 2 dates, March 7th and March 11th. And neither of those days was he actually there. And there's testimony from his supervisor that here's his schedule. He was not there. He was at home because he had a home accident and was being treated and texting us contemporaneously with the description of the treatment that he was receiving during that period of time. I just think that is an absolutely significant event that the administrative law judge completely ignored and the appeals board glossed over and rubber stamped it. All we got out of them was he's a dubious historian. I don't know if that's a fancy term for, well, it's questionable, or if it's a fancy term for he lied, but we're going to let him get away with it.
There were two doctors that the ALJ and the board relied on, as I understand it. One of them, I think, was Dr. Erickson. Is that correct?
No, they did not rely on Dr. Erickson. I wish they had.
Okay, so what, do you recall the two doctors that, am I correct that?
Yes.
Okay,
Yes, Judge Boozer. The two doctors that they relied upon are best described as work comp doctors because they're doctors that we see on almost every case. And what I believe was done at the administrative level was Judge Klein looked at what Dr. Hufford, who he's very familiar with, said. Dr. Hufford was the court-ordered IME. He was the doctor who was giving the court what was supposed to be a neutral opinion. Pedro Marotti is the other doctor, and
for the plaintiff.
yes, and I don't think I'm stretching to say that he's very claimant friendly. I could likely walk into his office right now and be found disabled.
Here's the question. Did these two doctors that were relied upon, their opinions were relied upon by the ALJ and the board, were they aware or informed of the bathtub incident?
They were not. Dr. Marotti was not, at least not by me, because I knew that would not make a difference. Dr. Hufford was the doctor whose deposition some of this evidence came in very late in the case. And that's just the nature of the procedural manner in which we try cases in work comp. The first full hearing is a regular hearing. There are depositions taken before that, but evidence is put in after that, typically over a period of about 60 days.
And were both of these doctors then, they were not informed of the bathtub incident in any way through medical records or prior testimony, but were they informed as to the so-called tire incident?
They absolutely were, and they both put it in their records that this tire incident occurred, and I think the substantial competent evidence demonstrates that it never occurred. It certainly didn't occur.
You're going into your rebuttal time.
Yes, thank you.
Mr. Leahy.
If it please the court, Your Honor, I think that you do have to find that the claimant's credibility is suspect all throughout this claim in order to reverse. And that just isn't supported by the facts. We had no,
Mr. Wood has some credibility problems.
well, he does, but I think it's more of a memory problem than it is a credibility problem. When he was injured in March of 2022, he did not feel that that was a significant injury. He never requested medical treatment from the respondent. They never offered any treatment.
Description of the mechanism of injury changed substantially.
His,
correct?
no, I don't believe his description of the mechanism of the injury ever changed. I think what changed was the fact that he couldn't remember the date on which the lifting of the tire injury occurred.
Isn't there fairly clear evidence in the record that he went to the chiropractor in March, and there was a discussion about him falling into the bathtub? I mean, I gathered he was cleaning and he fell into it and injured himself. Then later at his deposition, he's talking about an on-the-job injury in March, which has prompted you to initially file a claim based on that. No, you didn't file a claim?
We did file a claim, but not initially. That was not our initial claim.
After the deposition you did.
Right.
But, I mean, those are, the gap between a work injury and injuring yourself in the bathtub is pretty monumental, isn't it?
I agree. He definitely did not injure himself at work on March 9th of 2022. He wasn't working that day. I think that Dr. Zouderer, the chiropractor that he saw, her history that she took was that he injured himself when he fell in the bathtub. I think that's true. But if you look at claimant's testimony to virtually every doctor, is that he hurt himself once or twice a year at work, didn't report it. He went on to work. He had a very heavy job as his supervisor testified to. And I don't think that he saw the injury in March. He didn't remember it clearly, obviously, even from the very first time he testified to it, he didn't remember the date on which it happened, but he didn't see that as significant. And I think that's important.
Did your client ever admit to falling in the bathtub?
I think he did admit to falling in the bathtub, and he didn't remember when that happened either. But I think that he did, on cross-examination, admit that to falling in the bathtub. But it wasn't a significant injury. If you look at it, he saw a chiropractor one time. She provided an injection. She didn't ask for him to come back and see her again. She didn't make any referrals to any other doctors, and he went back to work doing his regular job. Now, there is testimony that he had help doing his regular job.
That's exactly what I was going to ask for. That is that late in the process, the employer comes forward with various employees who say they assisted Mr. Wood after the March incident for some extended period of time. How does that impact the opinions of the doctors? I mean, particularly Maradi and the independent medical examiner whose name escapes me at the moment.
If you look at the testimony of doctors Maradi and Hufford, whom the ALJ and the board relied on, what they said was that the impairment that they gave and the work restrictions that they gave are there because exclusively from the August 19th, 2022 injury and not from the March 9th, 2022 injury. And the reason for that is because he didn't receive any treatment following the March 9th, 2022 injury. No doctor placed any restrictions on his activities. Why the employer provided help with his heavy lifting, I don't know. There was no doctor that said he needed help with the heavy lifting. And he only saw a chiropractor one time. He didn't receive any significant treatment.
I mean, I assume the employees were helping. I mean, I didn't read the deposition, but I assume they were helping because he asked for and needed the help.
There's no testimony that he asked for or needed that help. The testimony is that they provided that help. His supervisor said that the only help he instructed other employees to provide was lifting the heavy tires and wheels. That's the only thing he said, and that they did it occasionally. If you look at the three witnesses who testified, they said, well, we were there working in the paint booth, helping him 2 hours a day, every day. Well, that's 6 hours. That's half the time that they worked in a day. I don't think that's very credible. And I don't think an employer would provide that when there was no medical evidence to show that he needed that help following the first injury. He had no restrictions on his activities. He didn't receive any treatment other than one visit by a chiropractor, and that was it. And that's exactly why Dr. Maradi and Dr. Hufford found that the August 19th injury was a significant injury because he was injured. He saw a chiropractor for 3 months. Respondent then authorized him to see Dr. Moore. She orders an MRI. First time he has a a test to objectively determine what's going on. The MRI shows two herniated discs. They authorize Dr. Erickson, an orthopedic surgeon. Erickson goes in, wants to provide treatment. My client doesn't want anything other than holistic treatment. It's just the way he is. He had one shot, I believe, maybe not even a shot from Dr. Erickson's office, but all he had was physical therapy, which he testified didn't help. And so that was the main reason that Doctors Hufford and Marotti testified that the August 19th injury was the significant injury that led to the restrictions that they placed on him and his work disability.
When they offered those opinions, were they aware of the assistance to whatever degree it was other employees were providing Mr. Wood between March and April?
I don't believe so. Yeah, I don't believe so.
Does that render their opinions not credible?
In my opinion, no, because there were no medical doctor or even a chiropractor had placed any restrictions on his ability to work. Nobody ever did. Even Dr. Erickson felt he didn't need restrictions to work. I mean, that's why Hufford and Marotti said that the August 19th injury is the significant one, because he didn't have significant treatment after the first injury. Nobody provided any limitations on his activities and restricted his work. I mean, the employer wasn't bound to modify his job activities, because no physician had ever indicated that he needed a modification of his job activities. And his supervisor, Mr. DJ Feast, said that he went back performing his regular job with the exception of lifting the heavy tires. And his regular job, if you look at the job descriptions from Paul Harden and Steve Benjamin, was a very significant heavy job. And he performed that job from March through August 19th. It wasn't until August 19th that he saw medical doctors who provided treatment and placed restrictions on his activities for the first time. And that's when the employer had an obligation to modify his job and put him on part-time activity. And I think that was important to Doctors Hufford and Marotti. And the board and the ALJ's decisions are supported by substantial competent evidence. They have two doctors that testified that the August 19th claim was the claim that resulted in all of his impairment as a result of this injury, and the restrictions that were placed on him, which resulted in a work disability. So that is substantial evidence.
Did the ALJ or the board have allowed the redeposition of Dr. Hufford to provide him with, I mean, I presume to provide him with that additional information and determine whether it affected his opinion?
The ALJ, Mr. Emerson scheduled a motion with the administrative law judge to request that the ALJ give him additional time to take Hufford's deposition. And the ALJ was aware of the testimony, heard Mr. Emerson's arguments, and knew the facts of the case by then. And it's reasonable and within his discretion to exclude that testimony. He allowed the testimony of the three witnesses, the workers that assisted my client when he didn't have to. They were beyond the terminal dates, but refused to allow him to go back in and examine Dr. Hufford. And I don't think, at least I can't see that Dr. Hufford would change his mind. The claimant wasn't restricted or placed any limitations placed on his activities. The employer did not have an obligation to provide any of that help. And so I can't see that Dr. Hufford's going to change his mind based upon testimony that three people helped him perform his job. And
Would it be better, at least for us, to know whether he would have or not?
well, I don't know the answer to that question, maybe, but when do you put a stop to the placing of additional evidence into the record? I mean, this guy was hurt almost 4 years ago. The last injury was almost 4 years ago. And here we are in 2026. A significant amount of evidence was placed into the record. 13 depositions, I believe, 13 transcripts were placed into the record. When do you say, well, you know, that there's been enough here? And especially in light of the fact that no restrictions were placed on him by any physicians. Why did they offer that help to him? We'll never know the answer to that question. Regardless of
Refresh my recollection, what did the ALJ say about the bathtub incident as it relates to his decision? Did he say anything?
as it relates to the ultimate work disability, the ALJ concluded that it was not a significant injury.
And the board accepted that
Correct,
from the ALJ.
correct. I mean, the board read, they're a finder of fact. They read the evidence and made the determination that the first injury was not a significant injury, did not contribute to the restrictions or the impairment rating, as the two doctors testified that it didn't. And they agreed. They felt that it was substantial and competent evidence to have two licensed physicians indicate that the second injury was what resulted in the restrictions, which gives rise to his ability not to earn as much money and the ultimate determination of work disability.
And lastly, how did the ALJ evaluate the workers who testified that they were helping the claimant after that initial injury?
He recognized that they made those statements, that they testified that they did help the workers. But I don't know that he felt that was significant or commented that much on that.
He didn't make any credibility findings that the workers were not telling you.
He did not. He did not. But I think that you have to find that the ALJ abused his discretion when he decided not to allow respondent to take Dr. Hufford's deposition again. And the board has always said that they're not going to interrupt the ALJ's determinations in that regard, that he should have discretion to control his docket. Anything else?
Apparently not. Thank you,
This
Council.
went a little different direction than I anticipated, but that's okay.
Now I ought to ask you what
What
direction you thought it was gonna go. What do you think we should have been asked?
No, I agree. I agree that you answered the right or asked the right questions. So thank you.
Before you jump in, let me phrase this correctly, and I have no expertise in work comp other than what I've learned as an appellate judge. You are not contesting the computation of the award here. I mean, that's not an alternative argument.
Not at all. We believe the award was based on the wrong physician's opinion on permanent impairment. We absolutely believe.
Right, and again, without sort of suggesting how we come out, but if we essentially credit or affirm the board, you don't have an alternative argument that Wood is getting too much.
That the calculation was wrong. No, I don't have that argument. Calculations were correct if in fact he sustained a 61% work disability.
Well, I assumed that from the brief. I just wanted to be sure that I wasn't overlooking something.
Okay. And I feel like I'm going to need to talk like an auctioneer, and I apologize in advance for that. This wasn't a situation where you've got a claimant with memory problems. I think the board was being kind when they said he was a dubious historian. That phrase has stuck out in my mind since they issued their order rubber stamping what Judge Klein did. The answer to some of these questions about how did the judge deal with the information from the three coworkers, he dealt with that in about 3 sentences. He dealt with the backwards fall into a tub just by referencing that a doctor said it. He didn't do any kind of analysis of it or the significance of that event on the subsequent injury. The fact that this is being referred to as that first event was not significant. If you look at the fact citations to the record, claimant couldn't walk. Claimant went into Dr. Zotterer's office bent over at the waist because he couldn't straighten up. When you look at his subsequent description in his testimony of what that first injury was like, he describes it as extremely significant. He even says later, I was working with a hurt injury. He was referring to when he went back to work after the March event, and he had to use the help of his coworkers in order to perform his job duties. So to suggest that he was actually returned to full duties, and that's what Doctors Hufford and Maradi based their medical conclusions on, were two things. Well, he didn't get a lot of treatment. Claimant himself said, we're holistic. We treat ourselves. It's not uncommon for claimants' attorneys to ask doctors specifically, don't give us any restrictions. Don't give us restrictions on this particular case. They do it for strategic reasons. That doesn't apply in this case, but this gentleman made it clear. I'm going to use MSM powder. I'm going to use turmeric. I've got a back brace already and some naproxen. I'm going to go that route because I don't want a lot of treatment. When he ended up treating with Dr. Erickson, he did the same thing. Dr. Erickson informed him, hey, we have an injection that can help you. What do you want to do? I declined that. Well, he sure accepted it after that first event in March when he fell in the bathtub. He had a very aggressive pain modality offered to him, and he accepted it because he wanted to be able to stand up again. He wanted to be able to walk upright. And we've just, the amount of evidence that supports from three different witnesses in this case that supports that first event was extremely significant. For me, it was very significant event, lifting a 17-pound spring assist door, very insignificant event. Doctors Maradi and Hufford only had the information from him that on March 7th, on March 9th, on or about March 9th, it's still that time frame within which this one injury of two, and that's claimant's words, we're only talking about two injuries. So his two injuries had to be that subsequent lifting of the 17-pound garage door and something that happened in March, because he consistently, in his treatment with the docs, consistently said, 5 months ago, something happened. 5 months ago, something happened. He was only honest to the doctor who treated him contemporaneously with that March event that did not happen at work. And I think that has a significant impact on that later injury, because that was an aggravation. Claimant described it as that in his own words, a re-injury. Claimant described that in his own words. Our statute doesn't allow for that to be a compensable claim. Our statute says that you don't get compensation unless there's impairment above and beyond what it was before, if you've got a pre-existing condition. And he did, and it had nothing to do with his work. So we ask that the board's order in this case be vacated, or in the alternative, I'd love to have what I had in the Turner versus Pleasant Acres case that was cited by Mr. Lee, which is a suspension of terminal dates so that we can get the information to the physician. In that case, it was also Dr. Hufford. That was allowed in Turner versus Pleasant Acres. He got the information that he wanted, and he changed his opinion because he determined that the claimant wasn't being forthcoming with the initial information. So that's what we wanted in this case. Unfortunately, it was denied, but I think this court has every jurisdiction to remand the case and allow us what we requested in the redeposition of Dr. David Hufford.
All right, counsel, thank you for your briefs and your arguments. We'll get something out to you as soon as we can.
Thanks so much.